name is LAW2053, MDA 2211033.
Hi, my name is Nur Alia bin Jasliza, MDA 2211040.
Hello, my name is Aina Nashita binti Basri, MDA 2211052.
Hi, my name is Nur Fatihah binti Fazil, MDA 2211034.
Siva, Chong, and Mukris are partners in Ohana Enterprise, with the primary purpose of providing interior design services for various properties. According to their partnership agreement, Mukris and Siva are responsible for contributing capital in monetary form, while Chong's contribution is limited to his skills and knowledge. Despite Chong not providing any capital, they have mutually agreed that both profits and liabilities will be equally divided among all partners. After a few years, their partnership became well known, and they began making significant profits. Siva decided to contribute more capital to the partnership as his earnings increased over the years. Additionally, Siva mentioned that the partnership should compensate him for each contribution, to be discussed and agreed upon during their meetings. Chong and Mukris, however, felt that there were no need to pay Siva for his additional contributions, as Siva himself had agreed to invest more capital into the partnership. This disagreement began causing financial losses for their business, as they struggled to reach a mutual decision on certain contracts. As the situation worsened over the years, Siva stopped communicating and negotiating with Chong and Mukris when dealing with clients. This lack of collaboration led to increasing frustration for Chong and Mukris, as they were no longer able to achieve a mutual understanding with Siva as their partner. Simultaneously, Siva opened a new business offering the same interior design services. When Chong and Mukris discovered this, they felt betrayed. They believed that in a business partnership, mutual understanding is crucial and partners should not compete against each other. As a lawyer, you need to advise Chong and Mukris for any action that they could take against Siva, and you also need to advise Chong, Mukris, and Siva for any rights that available under partnership.
Hi, Assalamualaikum. My name is Rufi binti Fazil, and today me and my teammates are going to talk about our assignment for Introduction to Partnership and Company Law. General issue. The issue in this case is whether Chong and Mukris could take any action against Siva and whether there are any rights that available under the partnership. Under the first circumstance, the law applicable is Section 36, Subsection C of the Partnership Act 1961, which states that a partner making for the purpose of the partnership any actual payment or advance beyond the amount of capital which he agreed to subscribe is entitled to interest at 8% per annum from the date of payment or advance. In other words, extra capital means a partner agrees to contribute additional capital to the partnership by themselves. Besides, the extra capital amount is greater than the amount he has agreed to contribute as capital. According to the law, the extra capital contributed by a partner that exceeds the amount he has agreed to contribute is considered as a loan. Consequently, the partner could not make the extra contribution as an increase in his contribution to the capital, especially if the division did not reach a mutual agreement. However, if the partnership stated about interest in extra capital in their partnership contract at an agreed percentage among the partners, then the partners must follow the percentage stated in the partnership agreement since the partnership deed was agreed upon by all partners. Hence, any misunderstanding could be cleared up by referring to the partnership contract.
As for the second issue that arises in this partnership, since we all know the dissolution of the partnership has a very wide discretion of the court, then the law that should be applicable under this situation is Section 37, Subsection F of the Partnership Act 1961, which is a dissolution by an order of the court on just and equitable grounds. It means the court may dissolve or turn down the partnership if the grounds applicable are non-existent. As an elaboration, the court will consider dissolving a partnership when the partners in the firm are no longer working together, have breached a deadlock, and the partnership has already faced a complete breakdown of communication between the partners in the firm. By so, the court may allow the application on just and equitable grounds. Despite that, if a partnership continues its business without having good communication between them in the firm, then the partners in the firm might face misunderstanding and the business will not function as well. Furthermore, pertaining to the above elaboration of dissolution of a partnership on just and equitable grounds, the partners in the partnership were no longer to have confidence in each other and the partner would have to show this in court. The example case on just and equitable grounds is Reality Tobacco Co. Ltd. 1916 2CH42. In this case, the relationship between the members had come to standstill and the company's business was thriving. However, the partnership only communicated through the secretary on the company when the members were not dealing and working together directly because they relied on everyday communication in the firm through the secretary and not by communicating with other person in the firm. Even though the partnership had made substantial profit, the court held that the firm should be one out and dissolve the company on just and equitable grounds because all the communication between all the members were made through the secretary.
In the issue between Siva, Chong and Mukris, Siva is the one who willingly decided to contribute more capital to the partnership. Hence, Ohana Enterprise, which is the firm, has to pay Siva for his extra contribution. However, Chong and Mukris refused to compensate Siva for his extra capital. But Chong and Mukris also did not refuse to receive Siva's additional capital. In fact, Siva's additional contribution is considered a loan, and Ohana Enterprise is required to pay Siva at 8% per annum from Siva's advance date, and Siva have a right to receive the payment of interest on extra capital from Ohana Enterprise as stated under Section 26 Subsection C of the Partnership Act 1961. Additionally, since Chong and Mukris did not provide any extra capital to Ohana Enterprise as Siva does, therefore, Chong and Mukris did not have any right over the interest on the extra capital. The extra capital provided by Siva did not increase the share of profit or the liabilities towards Siva. It doesn't impact Siva's liability because the extra capital contributed is based on Siva's willingness and it was treated as a loan. If Ohana Enterprise Partnership Agreement contains clauses regarding interest in extra capital, three of them must follow the agreed partnership agreement or they will be said to have breached the contract. As an illustration, the partnership agreement of Ohana Enterprise states that the partnership must issue 10% per annum from the date of the payment or pay 10% per annum from the advance, then the owner enterprise may be considered to have breached the contract and is liable for the act. In the second issue, SIVA stopped communicating and negotiating with Chong and Chris when dealing with clients, and there is an increasing frustration between Chong and Chris due to Chong and Chris disagreeing to compensate SIVA for his additional contribution. Thus, the partners reached a deadlock and faced a complete breakdown of communication between the partners in the firm at the same time. The consequence is that the court will consider to dissolve the partnership of Ohana Enterprise when the partners in the firm were no longer working together and communicating with each other. At this point, when Ohana Enterprise mutual confidence had been lost, thus the firm will dissolve its partnership by dissolution on just and equitable grounds. In conclusion, Ohana Enterprise has the right to pay SIVA 8% of extra capital or any percentage that was agreed between the three of them from the date of the advance. After that, when the partners lack mutual confidence, then dissolution on just and equitable grounds may occur. As a lawyer, it is advisable for them to clear their misunderstanding by seeking consultant for better decision making and having clearer understanding regarding the partnership agreement before they enter into the partnership. Besides that, the partner must follow the written law as agreed among them, or they will be considered to be breaching the contract. Lastly, in their partnership deed, they need to state clearly their interest in the extra capital for them to avoid misinterpretation. Subsequently, dissolution is not a good way for them to end their business. This is because the disagreement between them could be fixed. They need to try to communicate with each other again to conduct a more effective and efficiently business. Moreover, Ohana Enterprise should not dissolve their partnership because they have made significant profit and the business have been well known to the public. Hence, Chang, SIVA, and Lucas should maintain good relationship between the three of them to secure business success and learn to solve and adapt any problem that arises in the business.
That's all from us. Thank you for watching.